You know, there's a provision that says the eye can't say to the hand, because you're not an eye, I don't need you. I need my elbow, but I have a big mouth. There's a lot of different groups out here. There's a lot of diverse talents out here, gifts, abilities. It's time. It's time for you all to come into the fullness of who you were born to be. How do I know that? Because we're here. There are 4 different groups at least tonight, and each 4, you know, they're diverse groups. But in the end, the important thing is that we unite. We have to unite. We have to be one nation under God, indivisible, with liberty and justice for all. This is the logo that we selected for Tea Party Colorado. Paul Snover drew it for us. I want to just put a plug in for Paul. We knew that this was the national motto that Ben Franklin proposed that America should be brought under. Rebellion against tyranny is obedience to God. We thought that was fitting. 1773 was the original Tea Party. And if anybody remembers, that was, of course, a group of Indians, or founding fathers dressed like Indians. I understand Sam Adams was the leader of the gang. They took a stand, and they said, we're not budging. This is as far as you go and no more. They drew the line in the stand, and then they stood there. And here we are, because of what they did. Sooner or later, we have to draw a line in the sand and stop backing up. We're real good at drawing a line in the sand and backing up. And right now, we're being backed into a corner, and there's not much elbow room left. So, it helps to understand what we're dealing with. Our Tea Party group, the vision that we have is unity through knowledge, education, love, humility. We would like to see all the Tea Parties firing on the same cylinders, same engine, different cylinders. So I'm going to encourage everyone to find a group that you get along with, one that you can identify with, and plug in. How many know what a jury instruction is? Okay, it's not very many. A jury instruction, so you will know, when you go through a trial, you have the offense and the defense. At the end of the trial, the jury leaves, and both parties put together their version of the law. Now, the jury just got through hearing the facts. That's what the trial was for. The trial was so that evidence could be presented into the record, so that the jury could see the witnesses, and they could assess and judge what they think the facts are. And once they come up with what the facts are, now they have to compare those facts to the law. And so the lawyers now get to argue in front of the judge what jury instructions should go to the jury. Now, isn't that an interesting one? You got 2 parties arguing to the judge which instructions the jury should hear. Now, there's standard jury instructions that are pretty typical for most of your criminal cases, and there's civil jury instructions, and you got them in a book. But sometimes an issue will come up, and the 2 lawyers will argue about what they want the jury to hear. Now, the judge is the one that ultimately decides what the jury is going to hear. The judge is ultimately the one that makes the decision between the jury instructions that are being argued in between the jury going out for deliberation and the jury recessing. So, I'm sure Bob McConnell has had this experience many times. So the jury instruction, when the jury comes back in, the judge is sitting there with a stack of paper, and this stack of paper, they're called jury instructions. That's what they're called. And then the judge reads these things to the jury. The judge instructs the jury as to what the law is, that the jury will then apply to the facts to determine whether or not the defendant is guilty, or to determine if it's a civil action, which way the jury should rule. Okay, so the judge has a lot of control here, a lot of power, because the judge ultimately has the final say as to what the law is. Now what Gary was saying, as far as the jury has the right to judge the law and the facts, is a rogue jury will completely ignore the judge and completely ignore the law that the judge just read and come back with a verdict notwithstanding what the law had to say. There was a time in America where prohibition made alcohol illegal. They were having a hard time after a while being able to get a jury to convict someone that had been charged with a crime under the alcohol statutes. So the point Gary's trying to make, and I hear it a lot, is that the people ultimately have the final say. And the people ultimately do have the final say. But I'm going to tell you one thing, if you ever get on a jury and you get a set of jury instructions, you're going to feel really, really, really uncomfortable to go against what the judge says the law is. You will feel uncomfortable because activism is uncomfortable unless you're just naturally prone to rebellion. But America's founding fathers were naturally prone to rebellion because they had an allegiance to the truth. They indicted the King of England in the teeth of Romans 13. They indicted the King of England, King George, as being a tyrant, taxation without representation. They were activists. It was very uncomfortable. Being sovereign means you have to do the uncomfortable thing sometimes. That's the downside of being sovereign, is being responsible.